So this is our lawyer. Hope everything's alright. Well, both have. Listen, my supervisor, his case status laws has been following with discussion on the line. There's currently an offer which that would waive all arrears owed when we show him the fraud. Allow you to stay to June 23rd, the date of the court date. Interesting. Receive amount of 5,000 cash for keys in a timely manner. However, by this time, the convenience with proposed counsel is likely to withdraw, and it is not accepted, meaning that we would go to trial instead. Well, I told this guy I would go to trial, and then I look for this guy's name. Damn. Just give me a second, people. Okay. Okay, here you go. So they had said that, if we don't sign anything, that the judge won't take our evidence. And on top of it, I requested that while you're stating that you believe, listen, we're requesting formal case assessment in writing why you believe our evidence may not hold up in court, and why you, the lawyer, believe the judge will favor the landlord when we provide evidence of fraud on the court application. The landlord did, which we provided proof. There was deposit paid and rent paid to the landlord own. Responses, certified letter to the landlord. We were willing to pay the rent with no response from the landlord. We're not making any threats to the Bar Association. We are saying that what we said on the phone conversation, that we do not have rights for a case assessment to see if that's correct.
Do you have a date on that?
Yes. We suffered from what was done to us, and our decisions affect our life, so we must analyze and look over details to make sure we are making right decisions, not pushed towards a more damaging situation after we came out of one. So again, we're requesting a formal case assessment in writing why your counsel is saying our evidence may not hold in court, and possible dismissal, and may owe money with an eviction around 2 weeks from judgment day. This is a serious statement, and hold on. This is a serious statement. We need to assess not a money judgment, but dismissal. Why the council believes the landlord, even with the evidence of fraud and warranty and habitability and harassment and unlawful entry and the police reports, that they know proof but hearsay.
Yeah.
We can make proper assessment to make mature and wise decision for our future. We are not saying we will not take the offer, but we need writing requests before we can make a serious choice, because it affects our life. Thank you. Very professional. And this is what he said. sorry. Okay. This is supervisor attorney. Not disclosing his name. Okay. The email certified attachment. Okay, wait a minute. Okay, here it goes. Good afternoon. This is on May 15th. There are two basic types of landlord proceedings and non-payment procedures and holdover proceedings. In each case, the landlord must establish what is known a prima facie case, meaning the elements they are required to prove to court in order to prevail. In your case, the landlord commenced the proceedings as a holdover action. This action that the primary relief being sought is possession of premises, although the landlord may also seek a money judgment for unpaid rent and use of occupancy, which is not true. He kidnapped us. The prevailing and holdover procedure, the landlord must prove satisfactory in court. The landlord has proper standing to bring the proceedings. You are in possession, occupancy of present. The landlord property, he's saying the landlord property served the requirements, prejudicial notice determining your vacancy, which he did not prove that. And the lawyer is already siding with him without investigating anything. Because we told him that didn't happen.
Yeah.
You know, the landlord property properly served. He's saying he's saying he properly served. That's not someone's on my side. Terminating your tenancy, possession interest, and your right to possess has been lawfully terminated, and the landlord provides served notice of petition, the papers, which he did not. In the court. If the court determines that the landlord met the burden, that the court is awarded the landlord a judgment of possession and issue a warrant of eviction, possibly with no stay. Look at all this crazy stuff. A holdover proceeding, a landlord may also seek money judgment for unpaid rent and use and occupancy. The defense we are asserting in your case, specifically breach of warranty of habitability and breach of quiet enjoyment. It's more than that. You're not looking at our evidence. Are partially defenses to landlords' monetary claims. No, it's not partially, because we proved fraud. This guy's out of his mind. However, the defense generally do not defend the landlord's primary facet case, possession, and will not result in dismissal of the case. Yes, it is when he frauded, because that's fraudulent, and we proved it already.
Yeah.
If the court finds that there was a breach of warranty, a habitability, or quiet enjoyment, typically remedy is an abatement, meaning a reduction in the amount owed to the landlord, even if the court agrees the condition is in the apartment were improper. The council should still award the landlord possession of premises and issue warranty eviction while what does that say? Sorry guys. Only reducing the amount of money, any money owed in judgment. Alright, watch this. At the present, the landlord is offering a complete waiver of claims backed by the additional payment you and the co-deponent's $5,000 if you vacate the premises timely. Particularly affects response a full abatement of the landlord's monetary claims. Exiting case concerns breaches warranty or habitability and generally does not support full abatement, even if the case involves significantly and irregular conditions. Well, under the irregular conditions, we have the right to withhold rent if things are not repaired. And we have a police report stating that the repair was unsuccessful. According to, even if were to prevail on the affirmative defenses being asserted, the court could still issue a warrant of eviction, a warrant of landlord, partially reducing money judgment. It is that reason we recommend settling the case, and settlement cannot be reached, then we submit and answer a proceeding of trial. But I do not think that course of action is to your best interest. Please consider carefully what I have written and check carefully again in the next week and talk about how we could proceed this. Okay, so if you remember, I asked him, he completely avoided. We're requesting a formal written why you're saying that the judge will favor them. You know, why did you say that statement? He's stating that basically, you know, how it can go. He's pretty much predicting the case. And we produce fraud, we produce evidence of fraud of the filing. The case should be dismissed completely.
Yeah.
You know, and also we have a right to withhold rent when conditions are not, repairs not being met to law. So what is this guy talking about?
Yeah.
Our lawyer has been compromised. This landlord has some kind of connections and has been compromised. He's not in our favor, and everyone could see this.